In my last video, I discussed with you the general criteria by which the courts evaluate whether a will is enforceable or not enforceable. But let's talk now in part two of how to challenge a will, trust, power of attorney, the circumstances under which you can successfully challenge such a document. By and large, what you have to look at are the formalities of the will, trust, power of attorney. Secondly, the mental capacity, the state of mind of the person who signed the will, trust, power of attorney. And three, the circumstances under which it was signed. Often the strongest grounds for contesting the decisions made by a decedent or by a trust maker has to do with either mental defect or a lack of mental capacity, meaning that they're not of sound mind. They've been declared to be medically incompetent to understand the consequences of decisions they make, or two, undue influence. The third most important or frequently asserted claim to invalidate a will, trust, or power of attorney is fraud. So let's touch on them briefly, starting with the subject of fraud. Fraud is a term that's often used, and essentially what it means is that someone who believes that a person did not understand or did not mean to sign a document which purports to leave property to someone else, that person was misrepresented in terms of what they were signing or the circumstances under which they were signing it, or made representations to the person who signed the document as to a state of facts that were not true at that time, such that the misrepresentation to the maker of the will or the trust or the power of attorney changed their mind and disinherited a person from their estate, or declined to leave them a gift which they otherwise would have done. That is known as fraud in the inducement. It is commonly referred to as misrepresentation or fraud in the making of the document. The second most commonly asserted grounds to invalidate a will has to do with undue influence. Undue influence means simply this: that a person was vulnerable, that a person knew that this person was vulnerable, and because of that vulnerability, they achieved a dominant position. In other words, they were superior to that vulnerable person. It could be economic, it could be physical, it could be psychological. That person had such an influence over that vulnerable person that that vulnerable person made a decision to leave a substantial portion of their estate or their resources to the person of a dominant position. Undue influence means that that person so influenced the person's thinking that as a result of that influence, changes were made in what would have otherwise been the testamentary or the trust-like decisions of the person. The first grounds that I mentioned to you prior to fraud and to undue influence had to do with mental capacity. That simply means that the person lacked the cognitive mental ability to understand what they're doing. Common causes: Alzheimer's, dementia, Parkinson's, ALS, those diseases which affect a person's state of mind such that they do not understand what they're saying. Perhaps it's a physical disability, blindness, or a hearing impairment. Perhaps they come from another country and speak one language, and a person represents something to them to be a document other than what it was. That probably falls more into the fraud category that I described a little bit earlier. But you can see from the examples I'm giving you, there are a number of grounds which can be legitimately asserted to challenge a will, trust, or power of attorney. The question is, will those claims prevail? And that's a subject matter that I'll address briefly with you in part three of how to challenge a will, trust, or power of attorney.